Hi again. This is week 6. Week 6. That means we're almost at the end of this term. It's been a very short term to me. I think it probably doesn't seem that short to you because you're doing all the work. But the time seems to fly by every time I teach this course. This week we are truly back into the meat of the academic content of the course. And we're really getting into how a criminal trial is conducted. For most of you, this will be maybe the most interesting topic that we cover because most of you, nearly all of you, plan to go into some career that is related to the criminal trial process. Most of you don't seem to have too much interest in the civil side of things, although you may end up with some interest in that in your careers or in your personal lives. But for the most part, we're dealing this week with, entirely this week with the criminal process, and especially with criminal trial processes involving a motion for a change of venue. Now, you know what venue is. We talked about that in earlier weeks. Venue refers to the decision as to where a trial should take place. The fairest place, the most convenient place, the place that may or may not be mandated by statute or constitution. In criminal cases, as we've discussed before, the preferred venue, in fact, the mandatory venue in most criminal cases, is the place where the crime was committed. But for various reasons, sometimes even criminal trials have to be moved. And usually when that happens, it's going to be upon the motion of one of the parties, usually the defendant, but not always. Sometimes the prosecutor will ask for a change of venue as well. Those changes of venue are granted or not granted by the judge in the case, and they are based on evidence and evidence that is brought to the court by both sides, but based also on whether the judge really thinks it's a good idea to move the trial. Convenience does play a part. It plays a bigger part in civil trials than it does in criminal trials, but it plays a part in criminal trials as well. The most important factor, though, in determining whether a change of venue should be granted is the perceived justice to the defendant. The Constitution and decency require that criminal defendants be given the fairest trial possible. Sometimes when a criminal is tried in the place where a crime was committed, fairness or justice will be unlikely for whatever reason. Sometimes it's because there's been too much publicity. Sometimes the publicity has been adverse. Sometimes it's been too favorable. Very often what also happens is that you've got someone who, for whatever reason, is not likely to be able to find a jury of his or her peers. Maybe the jury pool is not sufficiently diverse, or the jury pool has shown itself to be too biased one way or the other. In those circumstances, the defense counsel will have the opportunity to ask that the court move the trial somewhere else. Now, when a trial is moved, when the venue is changed, it's not going to be changed from, say, Oklahoma to Maine. It's going to be changed from one city or county in the state where the crime happened to another city or county, not too far away usually. In a federal trial, when a motion for change of venue is granted, the venue is changed to another federal district court not too far away. It may be in another state, although that doesn't usually happen, but it could be. But in federal courts, the location, because the law is the same just about no matter where you are, doesn't matter as much as it does in state courts, although the matter of convenience, of course, is still present. Another thing that you need to think about this week, and this is really also getting to the justice that may or may not be served in a criminal trial, is the whole question of whether there should be mandatory minimum sentences for certain kinds of crime. In both federal criminal law and in many states, mandatory minimum sentences are imposed for certain crimes. That is always going to be statutory. There will always be, if there's a mandatory minimum, there will always be a statutory law, that is to say a law passed by a legislature that sets out those mandatory minimums and when they are to be used and when they can be ignored. Obviously, they can't often be ignored, otherwise they wouldn't be called mandatory minimums. So the whole question that you're going to be addressing in your short paper this week is the justice and efficiency question. Mandatory minimums do usually promote judicial efficiency. They make the judge's job, the judge is usually the person who imposes a sentence, they make the judge's job easier because he or she doesn't really have to think about the sentence very much. It's right there in black and white. You know, if you commit this crime, then you get this sentence. However, judicial efficiency sometimes comes head to head, as we have seen before, with justice to the defendant or to the state, to the people. So sometimes following those mandatory minimums actually does a disservice in terms of justice. Now, if the judge is not given any leeway at all, any ability to exercise judicial discretion, then those mandatory sentences have to be imposed no matter what, whether they are just or not. But sometimes they are simply advisory. They're recommended sentences, and they're really not mandatory. But in your short paper, you'll have the opportunity to research this matter and to discuss it, to also think about it and give your own opinion. What is the future of the mandatory minimum? In what crimes would it be? Would those kinds of sentences be appropriate? Very often, in state and federal courts, mandatory minimums will apply to things like drug convictions, and most people nowadays are coming to the conclusion that these mandatory minimum sentences for nonviolent drug offenders, and especially for first-time or low-level drug offenders, are really unjust. They are throwing people into prison who have committed nonviolent crimes that essentially don't really have much of a victim, and they are putting those people into contact with violent criminals. They are actually teaching these people to be better criminals than they are reforming them. Some of you in your previous discussions have talked about working with drug courts. So in some states, the move is away from the mandatory minimum jail or prison term for a drug offender, and instead has shifted radically to dealing with those minor, low-level, especially first-time drug offenders in a special court, in a drug court, that doesn't result in a prison term. Because the hope is that if you catch somebody for the first time on a minor drug offense, and you really treat them in a way that is meant to be effective, then that person can be turned away from a life in drugs, either as a user or as a dealer. So you really want them to become profitable and productive members of society, and to turn them away from illegal drugs. I won't get into that too much. I already have gotten into it too much because it's not our topic for this week. But I wish you the best of luck with this short paper. And as always, ask me any questions you might have via email or the general discussion board, and I'll get to you as soon as I can. Have a good week. Enjoy the topic, and I will see you soon. Bye.